So let's start. Welcome to the Nova School of Law. It is a great pleasure to welcome you today to this event on the regulation of innovation. It is a great pleasure to partner with the Legal Hackers Lisbon, whom I greet here in the person of João Vieira dos Santos. It is not the first event organized together, and I hope it will not be the last. It is also a great pleasure to open this event, considering the high level of the participants. I would like to welcome Eduarda Gonçalves, Ronald, Leenes, Teresa, Moreira, and Teresa, Rodríguez-de-las-Heras, Ballell. Thank you for your willingness to participate in this event. The event will also certainly be very well moderated by my colleague and friend Fabrizio Esposito, professor at the Nova School of Law. Technology, and especially its connection with law, has been one of the main focus of the Nova School of Law in recent years. Besides having been the first university in Portugal to introduce a compulsory course on law and technology in its undergraduate course, we also have a master's degree with a specialization in law and technology that is already in its second year of operation. The search for this master's degree by national and foreign students from the best universities demonstrates the importance given today to the link between law and technology. I would like to thank everyone for being here today. I am sure that the session will be very exciting and that we will all learn a lot throughout this morning. Without any further delay, I give the floor to João Vieira dos Santos to also say a few opening words.
Good morning, everyone. Thank you, Jorge. It's an honor being here representing Legal Hackers Lisbon. We firstly like to thank Nova School of Law, here represented by Jorge Morais Carvalho. Always an honor to be with him, such a great professor. We also would like to thank all the speakers, the high quality speakers that we have here, and our moderator, Fabrizio Esposito, for the very detailed preparation of this webinar. We, Legal Hackers Lisbon, are open to the community of Lisbon and Portugal in general. If you want to join, we have the Twitter, Facebook, and LinkedIn page. You can contact us by one of those social networks. We also have a WhatsApp group, which we discuss topics like this one, related to law and technology. And also you could participate and collaborate with us in this type of events. So please be in touch with us. We are open to everybody. We choose this topic, regulating innovation, after some events that we promote about fostering innovation and about protecting innovation. Nowadays, I think people are more aware of the risks that innovation and mainly technological innovation that is changing rapidly our way of life, it's posing us. So I think it's important nowadays to discuss and to find solutions about these risks and to discuss it with these high quality speakers and in a global manner, because there are global risks. So our idea was to have an international webinar so we can find solutions together. So we are going to the important part. I pass the floor to Fabrizio. Thank you very much.
So thank you, João. So my task as moderator is I want to be as minimal as possible, because we are here to listen to an exceptional panel, and I want just to explain to the audience what the structure of the event is going to be, and highlight when they are going to be able to intervene, and I strongly encourage you to do it, because it is so rare to have the opportunity to engage with scholars and professionals of this caliber. So I strongly encourage you to take this opportunity, and I would like to reinforce the kind request of Professor Jorge to open your camera, because for the speakers, you cannot, if you have not been on the other side of an event like this, you cannot understand, you cannot grasp how important it is for the speakers to see the actual faces of the people they're talking to, because otherwise it gets so robotic and inhuman. Whereas when you start seeing at least a few faces of the people you're talking to, this gives us very much a proxy of what it would have been to do these events in person. So we will begin with an intervention by the speakers, and my suggestion is to follow the strict alphabetical order that we have on the poster for that purpose. Then we'll have a first round of warm-up or broader questions, so that also the audience can perhaps feel less intimidated to engage with our speakers. Then we will give the floor to the audience. You can perhaps write me in the chat in private if you have a question, or you can just take the floor. I will manage the queue. Then we will focus more on the governance related questions, and we will have at that point a second round of Q&A, and that round of Q&A will lead us up to the end of the event. So here we go. Let me stop sharing my screen. So just 1 second. Following the queue, our first speaker is Professor Maria Eduarda Gonçalves from the Instituto Universitário de Lisboa. And please, Professor Maria, the floor is yours. Okay, so perhaps we move to our second speaker, and in the meantime, I will try to assist Professor Maria to fix her problem to the best of my knowledge. So the second speaker would be Professor Ronald Leenes from the Tilburg Law School, and where he is one of the pillars of the law and technology community. So, Professor.
I think Maria is on now. No.
No.
Okay, then let me take the floor, and you try to sort out that. Oh, where's my here? Okay, share and play. Okay, good morning. Thank you very much for inviting me to this sort of exciting event. It's a bit of a pity that we don't have a larger audience, but then again, it is Saturday morning, a very rainy day here in the Netherlands. So let's get going. Okay, where's me? Please. Okay, a little bit about me. As you already said, Fabrizio, I'm a professor in techno-regulation, so how regulation can and is embedded into technology, and thus affects human behavior. And a simple example of techno-regulation would be a speed ramp, which physically limits the speed that cars can take on the road. Obviously, I'm not that interested in speed ramps, but I am interested in how regulation enters into things like robots or ICT devices, even applications such as Facebook and what have you. Unfortunately, I don't have much time to do any research at the moment, because I'm also head of department of Law, Technology, Markets and Society, and that's a reference to lessons for modalities of regulation. We're a group of about 65 researchers at the intersection of law, technology and society. and we have, our group is composed of not only lawyers, but we also have philosophers, ethicists. I myself have a background in public administration, so I'm not a lawyer. The mostly harmless reference is to that students often find me intimidating when they first meet me, but then it turns out I'm actually a bit of a pussy, and I'm very lenient to everyone. In terms of my interests, I'm pretty much interested in regulation and how to regulate technology, and we'll get to that in a second. But if you want to, throughout my history, I think I've written a fair amount of work. I've done a fair amount of work on privacy, but also on AI. And given that I have a very short attention span, I'm hop all over the place. So I've worked on nanotechnology, a bit of biotechnology, RFID, you name it, it's been on my plate. So I'm very broadly oriented and not a specialist in any sort of topic. Now, regarding today's webinar, we had in preparation a number of questions that we will discuss later on, but it was less clear what we were supposed to do with the brief free interventions. And what I wanted to do is position myself a little bit, and from what I saw in the tryout just before the session, the Teresas and Maria will talk mainly about innovation. And innovation is really not my thing, or innovation is not my thing really, in the sense that I don't focus on innovation as something that we should achieve or should pursue, but it's something that is related to technology and technology development. And I'm more interested in how social technical change, whether you call that innovation or not, how that affects society and how we should deal with that. And to me, it's always a socio-technical system. So it doesn't make any sense from where I'm standing to talk about regulation of technology, although I've mentioned that a couple of times. But it's also always the interaction of people with technology that creates issues or something that I then become interested in. Okay, second thing to say then, related to that, is that there is, and we'll come back to that in the first round of questions, is the question then, so what are you dealing with? And there is a distinction made in the field a little bit about between regulation for innovativeness, which is trying to stimulate innovation and what it requires from law and other modes of regulation to create innovation and foster that. And as I said, I'm not too much in that field, and I'll position myself a little later. And the other thing then, of course, is that if you have innovation or socio-technical change, then we bump into all sorts of unexpected issues or undesired results or what have you. And then, of course, the question is, how can we steer this innovation back into the right track? And that's where I feel much more comfortable. By the way, within my group, there are also people interested in regulation for innovativeness, and these come typically from a law and economics perspective, whereas I come from technology regulation. Okay, now one of the things that interests me for quite some time now, for 20 years about, is that there is this sort of deeply embedded notion in lots of people, not only technologists, but also the public at large, regulators, what have you, is that whenever we have a sort of a new technology, then we need new regulation to cope with that technology. And I find that, it goes a bit like this. So we have a new technology, you bump into some sort of issue, for instance, in autonomous vehicles, that the road safety regulation, the Vienna Convention states that a car needs to have a driver. An autonomous vehicle doesn't have a driver, so we need new law to fix this issue. And so that's the intervention, and the intervention is then typically new regulation. Now, and this points at what I've called elsewhere the flawed law syndrome. So the idea that the law doesn't keep up with technological developments and innovation, and hence, if we have new technologies that create certain questions or issues, then we need to fix the law rather than do anything else. I mean, you could also say, well, if the technology produces adverse effects or something, given the regulatory frame that we have, we should stop developing the technology. But it seems always to be like, no, we need to fix the law, as if innovation is something desirable on itself. But I think that the other speakers will go into that. So here are a couple of examples. Google and car executives urge Congress to develop national self-driving car regulations. Uber urges New Hampshire lawmakers to introduce statewide regulations. Scientists are also concerned people, so robotic weapons researchers call for new regulations for 21st century warfare. Now, I'm not saying that we shouldn't have regulation for these three topics, but what I want to point out is that there is this knee-jerk reaction that if there is something going on, we need law. And I used to be in that field as well, but I'm slowly moving out of it and being more cautious and questioning. So it's not so much new technology requires new regulation. Well, maybe not, at least maybe not always in any case. For instance, if it ain't broke, don't fix it. We have carefully thought about regulation, and there are certain things we find undesirable, and hence we should look at the technology side and not so much on the legal side. And I only have 2 minutes left, so I'll speed up, but I'm almost there. So, and we've seen this with robots, with AI, with autonomous vehicles. There's this call, we need specific regulation for that kind of technology. And that reminds me strongly of Frank Easterbrook's intervention at a conference in 1996, where he talked about the law of the horse. And basically there are two versions of that, but which I'll mix in the remainder. But the idea is basically that you might want to have the law of the horse that describes everything about a horse, because then you know how to deal with that, and that is not a really good idea. And what Easterbrook called for was this notion of coherence. We have a number of well understood legal concepts like liability, like contract, like default, what have you, and you should try to fit the existing technology or the evolving technology as much as we can within this notion of coherence. I mean, look at a new phenomena from the knowledge that we all already have. But opposing that to that, and that is more novel and more European, is that no, we have certain social ambitions, social goals, and regulation might be the way to do that, and that would urge for more specific regulation. That's called regulatory instrumentalism. Now, the third thing and that's my final point, I think, is that we should not forget that we have a lot of instruments, but enforcement is clearly lacking on many fronts. So data protection, we see the GDPR is finally kicking in, the CNIL and others are taking action against the big platforms. So we should really do that. So now, if the law is broken, how do we fix it? Well, this is a model that I use in teaching, and it says, basically it questions all the fronts. So usually we don't know exactly what the technology is. If people scream that there is a problem, who are these people? Why do they consider something to be a problem, etc.? What is the existing regulation actually? That's also a big unknown usually with technology developers. And then if we want to do interventions, then it's not only new regulation, but also enforcement. And there's a whole bunch of questions. If you want to regulate, how to do it, who should do it, when, etc., etc. Now, let me stop here. I have a couple of more slides, but I'm over time. This is where I feel we certainly need to intervene. I don't know, probably you're not too electrical engineering minded, but this is a wall socket that you, a cable that you plug into one wall socket and then into another. Don't do this at home. You might kill yourself, or you might blow out the fuses of the entire region. And still, this is on sale on Amazon. So how can that be? I mean, if this is happening, then I would urge intervene. And let me stop here. Thank you.
So thank you, Ronald. That was an excellent first intervention for our audience. So perhaps we move to our next speaker and we try to continue solving the issue. So with our next speaker, we move at the highest possible level of governance that you can that we can think of in this earth, right? So we move at the level of the United Nations Conference for Trade and Development, and our speaker is the head of the Competition and Consumer Policies branch, which is you know, the area where actually I am more interested into. So personally, I really look forward for this intervention.
Well, thank you very much. First of all, for the invitation. Of course, I've known Jorge Morais Carvalho for a number of years, and I've had the pleasure of having him also intervene and collaborate with UNCTAD in my two areas. Thank you for João Vieira dos Santos, and of course to Fabrizio Esposito. Good morning to everybody. Greetings from Geneva. I should say that after hearing Ronald, please don't be misled into thinking I actually know anything about technology or innovation, so to speak, even though my organization does work in this area. So as Fabrizio said, I'm the head of the Competition and Consumer Policies branch of UNCTAD. I would like to very briefly introduce you to what UNCTAD is, because as you know, the UN system universe is so broad and so large that it's very difficult, I would recognize, for even law students or young lawyers or legal scholars to actually recognize UNCTAD. So I will very briefly share my screen. I hope you are able to see it right now. So I will go quickly just to tell you that a particular aspect of UNCTAD, and it's quite interesting because what I will highlight now relates a little bit what was said already by Ronald. So UNCTAD was established in 1964, clearly as an organization within the UN system, devoted to assist developing countries, and now also what we call countries with economies in transition, to better integrate in the world economy. So this was established with a very clear development-driven goal, making it in the second half of the 60s, 70s, and even during the 80s as an organization that was a little bit the counterpart what was in the past the GATT agreement, so the General Agreement on Trade and Tariffs, and WTO, so the World Trade Organization, of course, established later. So UNCTAD serving, again, I underline, developing countries and countries with economies in transition. Now, this raises very interesting issues regarding this broad topic, regulation and innovation, and how to best address it. But what we do is policy advice. We do research and analysis to support that policy advice, and what we call consensus building, which is like consultations and exchange of information leading to agreed deliberations by member states representatives, even though stakeholders are very much welcome and active in our work, and technical cooperation to support countries implementing the policies, the legislation, the advocacy efforts, awareness raising, etc. So of course, like for other UN organizations, our big framework of reference is Agenda 2030, where our areas, my specific areas, tend to relate to decent work and economic growth, so SDG 8, SDG 9, industry, innovation and infrastructure, SDG 10, reduce inequalities, in the sense that these public policies are supposed to reduce inequalities within countries and between countries, and of course 12, responsible consumption and production, and 17, partnership for the goals. Just for you to have an idea, in case you are missing this, so we have these 195 members that of course encompass all developed countries, but our focus is in the countries that you see here in sort of purple and blue, and I think that really sets the dimension and let's say the huge task that we have ahead of us, but that is extremely interesting. Now, among other things, UNCTAD, of course, does a lot of work on technology and innovation. Not my area, not my division, not my branch, but I felt it was worthwhile mentioning this because we actually organize the United Nations Commission on Science and Technology for Development. Again, this very focused goal of all our work. But I do believe that this is a very important setting to bring together experts from completely different areas, again, related to technology and innovation. And you'd have a lot of legal experts also on regulation. So I believe that this is interesting. Now, on my areas, because I would have to talk a little bit about this later on, the interesting part for me, I mean, having been with UNCTAD for just 4 years so far, is that UNCTAD is actually the custodian, so the guardian, so to speak, of these two, the only internationally agreed instruments on both competition and consumer protection. Of course, these are sets of recommendations. The UN set on competition was agreed upon 40 years ago by consensus through a resolution of the General Assembly of the UN. The same thing for the UN guidelines for consumer protection that were adopted in '85 and actually revised twice. So in a way, we are very well placed, first of all, to bring together experts, representatives from both developing countries, countries with economies in transition, and try to foster consensus, convergence. So I do believe that this is an important forum, and I would like very much that all the participants and my fellow speakers take this into consideration, because already from what I heard from Ronald, I could see a number of interesting areas of overlap that I would like to explore in the future. So some data related to the current research and development across the world. These are data from this year, already during the pandemic, because of course you need to have research and development to actually achieve innovation and to make, as we say, technology work for the many and not just for the few, which of course is very much linked with this idea of leaving no one behind. But that is of course a very high level aspiration, but as you can imagine, very, very difficult to achieve, especially considering that during the pandemic this year, the rate of poverty across the world for the first time really increased and probably will remain extremely high. Also, some recent data from the growing importance of leading technology companies. We all know GAFA. They've even got bigger, more important, richer during the pandemic outbreak, and this will remain in the same way. And this is where I think regulation in a way, but competition and consumer policies play a role. So I'm just going very quickly through this. Of course, this will be shared with all of you, but again, we also do a lot of work in e-commerce, either from a framework point of view or assisting countries with concrete needs. And what we see is that something that we were informally discussing before the webinar started. So how these platforms, so Zoom, Microsoft Teams, WebEx and others, Kudo, etc., are so useful and have supported us so much during especially the confinement period. But for a big part of the world, the fact that there are poor ICT infrastructures, the fact that a lot of consumers, individuals, don't have access to devices that allow them to attend classes online, to connect with their loved ones in other continents remains a big problem. And in a number of countries, even within Europe, the digital divide still prevents elderly persons, families with a low income, families that live in rural, isolated areas from really benefiting from what we now, fortunately for us, take for granted. So I wanted also to underline this. Now I'm getting to the end. I just wanted very briefly to say why did I thought of mentioning competition and consumer policies? Because of course they are based in legal and policy frameworks. They have the advantage of being only successfully implemented if other stakeholders, if market players, if civil society organizations, if consumers, if academics are on board. So I do believe that this is relevant for the discussion at stake. And I will leave here that, of course, this touches our policy recommendations for effective competition and for effective consumer protection actually cover regulation and, in a way, innovation / technology related issues. So I wanted to mention this. Now, I have here a couple of recent publications and research papers that we have drafted and published recently. But I would like, before I finish now, to say that I'm very happy to share a number of references that my colleagues from the Science, Technology and Innovation Division provided me. So some papers, books that I believe touch more upon technology and innovation than necessarily on regulation. But I would like to talk about a book written by two colleagues, one of them a good friend, Regulatory Delivery, that was published last year in 2019 by Graham Russell and Professor Christopher Hodges of Oxford University. It's not necessarily strictly connected to innovation or technology, but it does suggest a model for a regulatory delivery, I would say, very much in the line of this idea of 10 years ago, I believe, or so, of the EU smart but better regulation. So trying to improve the role, the content, the contribution of regulation. So I thought that would be interesting to share, and I will put this in the chat. Thank you very much.
So thank you. One of the challenges of being a moderator in these kind of events is that you need to be very imaginative, not to keep repeating yourself when you think these excellent panelists. So Maria, let's see if I fear it is still not working. So our next speaker, Professor Teresa Rodríguez-de-las-Heras, Ballell. I'm sorry, I'm still trying to get used to Iberic surnames. It is still very challenging. So she is professor at the University Carlos III. She is a member of the Council of ELI, and these are just one of the many things that you could say about her, but we want to hear from her reflections on regulating innovations instead. So, Professor, the floor is yours.
Thank you very much, Fabrizio. Good morning, everyone, and thank you, George, João, all of you for inviting me to participate in this stimulating and thought-provoking roundtable. I'm very, very pleased and honored to be part of this discussion. I'm going to share as well my presentation for the purpose of illustrating some of the initial ideas that I would like to share with you today. Before starting with a couple of ideas that I would like to discuss and share with you as a starting point, I would like to let you know that my approach is essentially based on my experience in two of the expert groups created by the European Union Commission for the purpose of dealing with technological progress. And in particular, the expert group on artificial intelligence and liability, and the expert group of the Observatory on online platform. And that is important because my idea is to, or try to contribute to this fascinating discussion from the perspective of policy decision. So what are the policy alternatives that are pondered and considered at a European Union level? And second, to insist a lot on my private law approach to the problem, because even I'm very privileged to be in the same panel with all the other speakers. I'm also participating in expert group of UNCTAD, United Nations Commission for the International Trade Law, and as you know very well, the UNCTAD has also a private law approach. So all my contribution has to be clearly framed within this private law approach and this policy perspective, essentially. So we're going to talk about regulation and innovation, and we are trying to find what are the friction points between them, what is the kind of interaction between them. So I propose, why don't we start, and that is my idea, with some thought on conceptualizing and describing what is for us regulation, what means innovation. And I think that is very important, because many of our proposals, suggestions, and views are extremely determined and conditioned by the prior conceptualization and terms that we are using for the purpose of designing this scene and this discussion and interaction. So let me please start by defining what is my idea and my understanding of innovation and regulation. And there is something that I would like to share with you, and is totally aligned with Ronald's views as well. So regulation has been facing technological and technical progress, as well as societal challenges for the entire history. So it's a natural adaptation, and it's a natural accommodating process between regulation and innovation throughout history. So probably the first question that we should raise is, if that is true, what is different now? So is innovation becoming so different today that we need to reconsider this natural adaptability, this natural malleability of regulation to challenges and changes? So for me, this is an image that, in my opinion, reflects very well how we are perceiving innovation in our today's society. So even if technology has been changing, in my opinion, something new is happening in the latest days. And I described this change with the idea of a first generation of digital innovation. There has been the first decades where digital technologies has been incorporated in our society and our economy. So I'm talking about the electronic first stages of development. And we are living today what I called a second generation of digital innovation or digital transformation, where we have a combination, a synergical combination of other emerging technologies, other emerging digital technologies in a kind of technological ecosystem. This combination of technologies entail the interaction between algorithm and artificial intelligence, big data analytics, distributed layer technologies and other platforms, Internet of Things that interact each other, creating what I consider a disruptive scenario for consideration. This disruptive scenario is different, and that doesn't mean necessarily that a new regulation is required, but at least put us in a situation of reconsidering, rethinking many of our presumption, many of our conception. It is different because it's disruptive. It is different because it's tremendously dynamic. And it is different, in my opinion, because it's multidimensional. So far, in my opinion, we have faced technological progress, assuming that technology is an instrument that gives us the opportunity to do the same things in a different way. More effectively, more massive, more expansive, but exactly the same way with new instruments, with new tools. My approach to the second generation of digital innovation is that everything is touched and everything is profoundly transformed. I think that technological innovation today is impacting on three layers. We have new structures and new architectures for organizing our economic and social activity. We have new services and new product, and we have new actors, social, governmental, economic actors in our society. So this transformation is total, is absolute, is multidimensional. Let me please give you some ideas of what I consider each of these layers. I think that today, one of the most fascinating impact of technology is that technology is creating a new architecture for society. So we have new architecture in our societies, in our economies. This new architecture provides us with new environment to run activities, but also to develop our social living. And that is very important. Platforms or distributed layer structure or systems, they are not simply a new way of distributing product. There are indeed, in my opinion, new communities, new private legal system. Let me be provocative. New states with new citizens, with new opportunities to do things differently. That is for me absolutely disruptive. But we also realize that there is another layer that is extremely impacted as well, because the combination of big data, the combination of artificial intelligence, the combination with that with some automation opportunities that we have in this second generation, make us face something that is extremely distorting our traditional distinction between person and goods. We have to face the fabulous opportunity of creating increasingly autonomous system. We're not talking about automation only. We're talking about the opportunity of creating autonomy. And that invites a deep reconsideration. On the one hand, do we have a regulation that is enabling enough of this new phenomenon? Do we need new rules for enabling the development of autonomy in artificial intelligence driving system? Or on the contrary, are these increasingly autonomous systems creating new risk? And if that is the case, do we need regulation to mitigate this risk? And let me just be close to the end of my intervention. We also have another layer that is fascinating, is the emergence of new actors. Actors that are emerging and disrupting or erupting in this new economy simply and thanks to the use of technology. And that is extremely important for regulation, because when we regulate subject, operators, actors. Do we need to regulate new actors? And that is very important, because one of the cycle that I see in this fascinating second generation is a very interesting cycle from intermediation, traditional intermediation, to disintermediation, where intermediaries disappear, but at the same time, re-intermediation. So new intermediaries appear. How we are going to regulate, if is needed, these new intermediaries. So one side of the problem is how we face, how we understand innovation, and the other one is how we understand regulation. And let me please conclude with this map of option. Okay, when we talk about regulation, what are we talking about? What kind of regulatory strategies we are considering and putting on the table? Are we talking about ex ante regulation, where we define what are the requirements to access the market? Are we simply talking about establishing legal duties and obligations for the purpose of mitigating the risk and protecting, for example, consumers? Are we using liability, and that is fascinating for digital intermediaries and platforms, are we using liability as an extraordinary incentive allocating mechanism to promote activities that are duly protecting and containing risk? Or are we simply talking about an ex post intervention, mainly based on competition law reaction when the market is at risk? Let me just offer you three alternatives for further discussion, if Fabrizio considers that they are a good idea to do that. Can we simply work on producing regulation that is based on change-friendly principle? technological neutrality, functional equivalence. Is that enough? Is a good idea? Base our regulation of a change-friendly principle that enable permanent adaptability to the change that innovation entails? It's a good idea to rely on this idea of regulatory sandbox. What is a regulatory sandbox? It's a way of regulate change, or is simply a transitory, a provisional mechanism to identify a new emerging technology? But what happened next? Is going to be our regulation obsolete when a new technology comes? Or is it a good idea maybe to start thinking about more collaborative regulation? A regulation where industry, communities, population are permanently imputing, they are permanently contributing and feeding regulation. Can we imagine a regulation that is permanently open, that is permanently dynamic? Let's think about all together. Thank you very much.
Right. So I hope that we can hear Maria now from her phone.
Well, are you listening now?
Yes. Yes, we are.
Well, I will try to share my screen through the computer. Well, because of course I don't have it in my iPhone. Well, I'll try. Let's see if it works. Are you seeing?
Yes.
Well, this is really a success. I'm sorry for all these difficulties. Well, thank you again for the invitation to this interesting debate. In the end, I'm relatively happy that I'm the last one to intervene. I think it will make some sense, because my presentation will be maybe of a more general or broad nature, and benefits from presentations that we have just heard, very interesting and stimulating ones. And taking this into account, I will in fact focus mostly on the response, the regulatory response, so to speak, coming nowadays from the European Union to address these challenges that we have heard already much about, particularly the challenge from the so-called digital era. Well, to start with, I would recall also following from what has been just said by our colleague, that there are specificities, I would suggest, in this digital era in respect of well, technologies, new technologies, and their impact on society at large. As we all know, digital technologies, maybe in contrast with other so-called conventional technologies, are pervasive. In fact, they cross society, economics, politics, etc. So they are not sectorial as most of the technologies that we knew before. And there is again a specificity, or an additional specificity of the revolution in technology that we are witnessing now, which is the change in the economic system that we are in face of. In fact, as we know, the so-called data economy, this economy which is more and more based on data, on exploring data, controlling data, is also characterized by the dominance of power transnational companies and the big internet access providers. Not by accident, some authors have called them the deciders or the data oligarchs. And this economy based on this central economic powerful enterprises, as we all know and has been largely being recognized, impacts not only on the economics and on consumers, on the services and products that we are using as consumers, as users of the internet in particular, but impacts on our political systems, on democracy, on fundamental freedoms, to an extent that so-called conventional technologies had not faced. So in this context, there are well, two statements that may clarify what I've been trying to focus on. One by the European Data Protection Supervisor, for example, when it wrote that the internet has evolved in a way that surveillance, tracking people's behavior, is considered as the indispensable revenue model for some of the most successful companies. So there is also the issue already addressed before of the growing automation of decision making in different aspects of our daily lives, which in fact reduce our autonomy and threaten basic freedoms that we are enjoying in democratic systems. And so the issue, well, the central issue where I would like to focus now is what the response of law, not only constitutional law, we don't have time to address this more general topic, but regulatory law is, how is regulatory law, particularly in the European Union, addressing these challenges. You certainly know that the European Union has been addressing these challenges of the digital era and the new digital economy through a number of legal instruments, recent ones, the General Data Protection Regulation, already mentioned, the Directive on Copyright in the Single Digital Market, and I think in a few days now, the European Commission will present a digital services package, which includes well, two main acts, the Digital Markets Act and the Digital Services Act. And well, to summarize, what I would like, in fact, to mainly underline is the fact that all these three legal initiatives converge on what I would suggest is a new regulatory paradigm, mainly one which leaves or delegates, so to speak, important regulatory responsibilities on the operators themselves, on enterprises, and in particular the big online service providers. The General Data Protection Regulation, the GDPR, has been let's say congratulated as an interesting and an important way forward with respect to the protection of privacy and personal data protection. But in fact, this GDPR centers its approach on so-called centers its contribution to the protection of personal data in the so-called risk-based approach, which in fact results in leaving data protection issues mainly to the data controllers to decide through data protection impact assessment, delegating on these online service providers the responsibility to notify breaches, etc., and reducing significantly the regulatory intervention by the public national authorities, namely the data protection commissions. along the same lines, the new copyright directive gives also, or assigns the main regulatory role to namely the digital platforms, to an extent that an author, for example, qualified his directive as promoting an EU copyright law that favors private ordering over public policy. And it is in the same line that the new digital services package evolves. So I would say that from these broad trends emerges the focus on a culture of responsibility by the operators themselves, and also the users. In fact, internet users in particular are assigned a number of rights, maybe sometimes new rights, which also delegate on the users, individuals themselves, on data subject in particular, an important part of responsibility to safeguard, to protect their rights. And this, maybe I have 1 minute, 2 minutes. Just to complement this idea, if we look at how the Council of Europe in particular is addressing these same challenges, it's interesting to note that there is a new emphasis in this regard, in regard of internet governance principles, in particular on multi-stakeholder governance, on looking at not only at the public authorities as the conventional regulator, but on the responsibilities of private actors, civil society, etc., to guarantee in the digital era the protection of the fundamental rights and freedoms of people. So my conclusion and my question, in a way, the issue I would like here to raise is the following one. The trend vis-a-vis regulation or regulating new technologies, regulating innovation, which is a concept that we are here using. In particular, the emphasis seems to be, in this respect, more and more on soft law and ethics in cyberspace, meaning the responsibilities by the operators and by the same token, in a, let's say, coming back of the role of the state, of the public authority, we maybe assuming that regulating the use of these new digital technologies in the global sphere is an impossible task for the regulator. Well, I will conclude with this citation from a recent communication by the European Commission, where we can read that the success of the General Data Protection Regulation should not be measured by the number of fines imposed, but by changes in the culture and behavior of all, and I emphasize, all actors involved. That's it. So, and again, sorry for the the disturbance in communication that resulted from my lack of computer expertise as far as running these new digital technologies are concerned. So thank you.
Thank you, Professor. Well, we are all struggling with technological challenges, and I think it is it fits with the event that we're dealing with the topics of today, to see these challenges, how they play out in practice. So if you could stop sharing your screen.
Yes.
Okay. Great. So right now, we have had the inception interventions by the participants to the roundtable, and there is a number of topics that is on the table already. So I'm sure that participants understand that this is such a rich and complex and multi-layered field of research and societal challenges, of course. Right now, I have prepared together with Legal Hackers and with the input by the speakers some questions. We begin with a really icebreaker, so it's a question that, you know, should really signal to you, the audience, that this is a friendly environment, a safe space, almost a sandbox if you want, where you should feel free to participate and to engage with our speakers. So the first question is, can you name the one single book that you would recommend to someone who approaches the topic of regulation for innovation and regulation of innovation for the first time? And again, I would suggest that we go in alphabetical order for the sake of simplicity. So the first one would be Professor Maria.
Thank you. The literature on regulating new technologies and innovation is, of course, very broad, and but since you have asked for one suggestion for kind of literature that may help a student, I imagine the student, to address this the topic that you have that we have approached in this workshop, I would suggest not a book by authors, a conventional book, but a report by the OECD, and also underline that the OECD has been addressing policy for science and technology for many decades, innovation policy as part of that, and has been recently discussing the governance of innovation and implications for regulatory frameworks. I found, I have just gone through it very quickly, but the proceedings, I think, that of a global conference on governance innovation towards agile regulatory frameworks in the fourth industrial revolution, which is from 2020. And the work of all the papers produced for this conference, overall, I think, provide a very updated view about these relations. So I can send the reference through the chat, maybe.
That would be perfect.
Okay, that's my suggestion.
Thank you so much. Ronald?
Yeah, it's actually a very tough question, and as Maria said, there are of course lots of books on sort of specific aspects of innovation and regulation, but I don't think that there is actually a really good book that brings the two together and talks about innovation and regulation in a coherent manner. So and also I can't count, so one doesn't say anything. So I came up with 3 suggestions, and they all 3 sort of go back a little step, and as I also try to outline in my intervention, is that I think it's important to understand what regulation is. I think we're mirrored here, but this is my first one. It's an oldie already, 2012, I believe. I'll put the link in the chat in a bit. It's an introduction to law and regulation by text and materials by Bromwell Morgan and Karen Young. And the reason why I find that book important is because it starts from the whole notion of why should we regulate in the first place. So I mean, lawyers have this tendency to indeed intervene, but coming from a law and economics perspective, people would say, no, don't intervene in the market. The market can handle it. So, and so Morgan and Young go back to the whole reasons why we should regulate, and then talk about the various difficulties in touching upon that. If you want to have it a bit more related to actual technologies and practical things, then we end up with a book written by Roger Brownsworth, who is one of my heroes in the field, and Morgan Goodwin, a colleague of mine at Tilburg Law School. It's also a little bit dated because they talk about technologies that are no longer considered to be emerging technologies. But it's a good overview. And thirdly, a paper that I also use for teaching, written by Anna Boutenko and Pierre Larouche, both former colleagues of mine, that bring together this notion of regulation for innovativeness and regulation of innovation. And I talk about what innovation is and how you can stimulate innovation in a relatively comprehensive paper form. So those are my suggestions, and I'll put them in the chat.
Thank you, Ronald. More than one is fine. There is no problem with that. Thank you so much. So, Teresa?
Thank you very much. I also could not find a single book. I already mentioned one that is more on regulation, so to speak. Frankly, having a legal background, and even though I've had experience at national level as an enforcer of both competition law and consumer protection law, I have very, very mixed feelings about the need for regulation, even though, again, I'm a lawyer. Maybe because I think one needs a legal framework, but to, as Maria Eduarda's presentation mentioned, in the end, I think the point is actually to influence the culture. The thing is that you cannot change culture, and you cannot influence behaviors if there isn't a predictable, stable environment, and this is usually brought by some sort of regulation. I have shared, so I talked about this regulatory delivery book, which of course does not necessarily relate to innovation in a direct way, from Professor Christopher Hodges and Graham Russell. I've already put also the reference. I sent this to Fabrizio. I have heard, and I have indicated a number of UNCTAD reports on, I think, technology and innovation policies that participants may find of interest. I now find out that the colleague suggested a book by Professor Christy Ford entitled Innovation, Regulation and the State, published by Cambridge Press University, that I believe may be a good sort of initial approach. Thank you.
Thank you, Teresa. Teresa Rodríguez-de-las-Heras Ballell, I did better this time.
It's improving incredibly. Thank you very much, Fabrizio. I have already posted 3 reports as well. I think that is a very good point, very effective to start reading some very clear and extremely updated report by international organizations or expert group. So I have suggested 3 of them. I particularly recommend the second one, that is 30 recommendation on regulation, innovation and finance. Is the expert group of the European Union that tried to suggest how to raise regulatory obstacle for promoting and fostering innovation in the financial market. So it's very focused on financial market, but this idea of identifying policy obstacles, regulatory hampers, and then suggest recommendation is a very agile and fresh way of understanding the interaction between regulation and innovation. So that is the reason why I suggest that one as a very, very good start. Thank you, Fabrizio.
Thank you. So now I have shared the suggestion by Teresa Moreira. We move to the second question, which is again a bird's eye picture, bird's eye view question. So we have been talking about many general issues and to some extent more specific issues, and now with the hope of inspiring, right, our audience, I would like to ask you if, in your opinion, there are areas that we are overlooking, so they are below our radar, and if there are areas that are receiving too much attention, because also that's the way academia to some extent works. Something gets fancy, and then at some point everybody starts focusing on it. So again, Maria.
Well, sorry, I'm just regulating my sound. Well, so your question relates to whether there are missing areas, no areas requiring consideration which may not be in the center of attention. Well, it's hard for me to answer the question you've raised. I've been addressing in my research mostly these digital technologies, although in the recent past I have also been well, researching and teaching on, for example, environmental regulation, risk regulation of technologies like GMO and similar ones. With respect to legal research and even sociological research on these topics, well, my impression is that there is much work going on, right? Even new journals emerging on these topics. Well, in fact, I cannot identify a specific area requiring more attention that it's giving to them. So,
thank you. That is reassuring, at least. Let's see if everybody shares this optimistic view. Ronald.
Yeah. First, I want to start with noting that probably everybody has their own sort of filter bubble and tunnel vision, so that we're really focused on the topic that you're currently focused on is the attention of the entire world, which probably is not the case in actually, but I think there's a little bit of overhype in attention for AI and robotics and whether that should be regulated. I think coming back to the law of the horse idea, I think many of the traditional legal regimes cover lots of things that happen in that space reasonably well, and we haven't gotten our head exactly around what needs to be done there. Another thing, and I'm not entirely sure whether it's overlooked at the moment, because there's a lot of attention, of course, on platforms. And the upcoming package next week is really going to be important there. But I think one of the things, there are a couple of things with platforms that are really I think need to be put more on the table, and that is how platforms steer innovation. GAFA was mentioned. The way Amazon steers innovation by kicking off stuff from the platform. And actually determining what people can see. Same for Google, of course, and to a lesser extent, I guess, for Apple and Facebook. But these platforms really provide an eye to the world on the world. So what exists on Google and Amazon is there, and if it's not there, then it doesn't exist somehow. Amazon also makes use of what happens downstream. To then enter the market and kick people out of business, basically, and I think that's actually fairly worrying. And that's coming to the second point that I wanted to say about platforms is, and it was mentioned already also in, I think Teresa Rodríguez mentioned that the trade-offs that are traditionally made between public interests and private interests are done by regulators. I mean, that was how it used to be, and now the platforms decide an awful lot of things. I mean, I wouldn't go as far as call them states, because I find that a problematic notion, but the power that they have in deciding public policy in a sense is worrying. One of the examples is, for instance, how Apple and Google teamed up to provide the infrastructure for making COVID tracking and tracing applications possible on smartphones. I think they did the right thing there, but it's slightly worrying that two private enterprises basically run the show and determine what states can do then. A third observation I want to make, and that's in a totally different way. I think, of course, being in this whole digital thing is seeing that as the core, the center of the universe. Maybe we have bigger issues. Climate change is way bigger, and I think we need to focus more in. If you want to talk about innovation, then let's talk about how we get how we can make the energy transition work. We need a lot of innovation there, and probably we need a lot of regulation to make that happen. And of course, I agree totally with various speakers that it's not about fines. It is about changing behavior and changing of cultures. But a way to do that is through regulation. Thank you.
Thank you. So, Teresa Moreira.
The first Teresa, just because of the ardor. One can see that both of us are from Latin Catholic countries, I suppose, to have this first name. No, I think it is difficult, as other speakers mentioned, to see what is overlooked. I would suggest something, picking up on what Maria Eduarda mentioned regarding the cultural responsibility, and also bringing back some of the references that Professor Christopher Hodges has been very much exploring. An idea of ethics being, how can I put it, being fully grasped and complied with by big market players. I would suggest obviously the big the digital platforms, but this can apply to other areas within the innovation landscape. Because again, I am a believer in regulation. I do think that, as Ronald said, of course, that digital platforms and big market players have huge power. And even when we are very happy that the European Commission and other, just to give an example, competition authorities, or the recent decision by the French regulator on data, they are extremely good measures and convey very powerful messages. But these, as we know, the amount of fines and the concrete impact in the businesses of these companies is extremely insignificant. So we still need a combination of instruments, of tools, of areas. This is what I would say. It's probably that we are still somehow overlooking. So competition experts deal with competition, sector-specific regulators, either on data or electronic communications or on financial issues, also focus on their very complex areas. Consumer protection also a little bit, and there's still quite a lot of work in silos, but I do believe that this needs to be complemented by the soft law instruments, by ethics, by standards, by good business practices, etc. Thank you.
Thank you, Teresa Moreira. So now, Teresa Rodríguez-de-las-Heras Ballell.
That's perfect. Now cannot be improved. It's perfect. Thank you, Fabrizio. So I completely concur with Ronald that when we approach this question, we are indeed screening the attention that is given to certain aspects from our own filter bubble. And that, for example, is very clear in me. No, I know quite well what is being done on artificial intelligence and robotics and data and platforms. And personally, I'm consciously or not overlooking other areas. So that's determine a lot how we understand the regulatory attention. Taking into account that, I think that we are extremely focused on digital technology-based innovation. So there is a clear idea that innovation is linked to digital technologies, and in particular is linked to artificial intelligence, big data, Internet of Things. So this idea is probably making us overlook a lot of other kinds of social innovation, financial innovation, environmental issues, for example. Probably, even if they are not disregarded at all, but probably they are not at the core of regulatory attention. Within this area of digital technologies innovation, I see a significant attention on data. This idea of the data economy is becoming obsessive in a way that we're extremely concerned about data. I'm not talking non-personal data, personal data, but also non-personal data as well. So data is definitely extremely attracting attention. We, as Ronald mentioned, artificial intelligence and robotics as well is attracting attention. And I completely agree with Ronald that the attention that platforms are capturing is biased, because it's extremely focused on competition aspect, gatekeepers, influence, market power, and probably risk and drawbacks of platform. And I see platform as a new way of organizing our society. And in that regard, I think that platforms as regulators, as Ronald mentioned as well, and platform as new communities probably are oversighted. They are eluded, or they are not, they are definitely not dealt with as it should be. For example, the relationship between platforms and human rights, platform on disinformation, platforms are populism or nationalism in international context. So this, on the one side, not necessarily economic aspect of platforms probably require, in my opinion, a deeper attention and a careful attention. Thank you, Fabrizio.
I missed the last part of Teresa's intervention, but I'm glad that everybody else could listen to it until the end. So my next question is the following. So there is this idea that the regulation, in particular of innovation, creates bottlenecks, so creates obstacles. But why, or in what ways, should regulation be also perceived as an asset for business and for innovation? So again, we follow.
May I say something?
Of course.
Yeah. Well, I maybe not the most competent entity to address this specific interface between regulation and innovation. I found very interesting what has just been said by Teresa Moreira in particular, on and also by Ronald previously, on the emphasis nowadays on the digital technologies, in particular artificial intelligence, robotics, etc. I would just comment that this emphasis, which is to a large extent also media driven, of course, is related to the relative novelty of these technological developments, and also their pervasiveness, in particular, i.e. this emphasis on data science, data economy, etc., is part of that. I would not understand that this emphasis implies undermining other relevant issues in this connection on the environmental regulation side, etc. There were times in our contemporary world in which the environmental topics were the main topics addressed in the public sphere, etc. Well, just to try to address more specifically the question Fabrizio has just raised, I would come again to this central topic of regulating platforms and what they imply. Just recalling that in this week already, as the European Commission presents its package on digital services and digital markets, Google, for example, I think Google or Facebook, but Google reacted questioning that regulating markets in particular in these areas, while this attempt to or intention to possibly break the structures of enterprises like Facebook and Google will stifle innovation on the one hand. On the other hand, will stifle creativity. So this, I conclude now, I think raises also a new issue in the present context concerning the relation between competition, promoting competition in the markets, and innovation. Because the conventional idea, what I've learned in courses on competition law, was that competition promotes innovation. And now we see the big transnational companies in this digital sphere arguing that breaking their structure, controlling the state controlling the workings of markets stifles innovation. I don't have, of course, an answer to the issue, but well, I will stop here.
Thank you. Ronald?
Yeah, Maria is completely right. Of course, the whole idea of competition is that it promotes innovation, and that actually Google is very anti-competitive, and talk as coming from Google stating that regulation stifles innovation is, I find it actually very, very boring and very suspect. Another thing, and also I'm totally not convinced that regulation actually stifles innovation. I teach data protection and intellectual property law to data science students, and they're always like, okay, you're going to talk about the GDPR and we can't do anything according to the GDPR, which is completely nonsense. I mean, it's a set of rules that you have to play by to do this game. Nobody ever complains about gravity. I mean, gravity is that's a really, really strict rule, right? It hasn't prevented people from inventing planes, and now people are pondering going to Mars and what have you. But having said that, I think, and I'm very much a European, so I think we have a European value set that is worthwhile, which is well developed, has a long history. And to that extent, I completely subscribe to what the high-level expert group on AI ethics has done, in the sense that these are the values that we should take a stance for. And then we have impact. So one of the really important ideas, I think, in, let's say, global policy is this notion of the Brussels effect, which was coined by Anu Bradford. And so the idea for people who don't know it is that because Europe is a significant market, or the EU is a significant market, people entering the market in Europe will have to play by the European rules, and that will lead companies from abroad, let's say the US, to adopt European rules and also promote them within their own jurisdictions. And that is one of the reasons why you see the spread of basic European regulation, which is completely unilateral, and it's not an organized process. But you see, even a stronger version of that, looking at the GDPR, I'm writing a paper with a PhD student of mine about the Kenyan Data Protection Act, which is almost a one-to-one copy of the GDPR. Brazil has adopted significant parts of the GDPR. California is adopting bits and pieces. Even China is adopting parts of the GDPR in their frameworks. So I think, and that provides opportunities for, let's say, companies within Europe, because they live in the GDPR regime already for almost 2 years now, right? So if the rest of the world is adopting GDPR-like regulation, then you can have sort of a starter advantage if you already comply with that coming from Europe. Another thing which is regulation that may stimulate innovation is data portability as outlined in the GDPR. So we have these big data players, but because of the data portability provision, people can ask for their data and move their data to another company, and that other company can actually offer advantages or a better deal for consumers, and that creates opportunities for smaller players in the market to gain part of the cake. Of course, there are others, but I'll give the floor to Teresa.
Thank you. Fabrizio, if I may. Thank you. No, very, very interesting remarks. I can only agree. Well, having worked most of my professional life, especially in the field of competition law and policy, it is true, not only for digital platforms. So any big companies, and Ronald, because you mentioned IP rights, for instance, nowadays, you know that pharmaceuticals and other companies that have to invest heavily in research and development, of course, they tend to look at regulation also as something that might hamper their huge investments that are needed to advance science and to achieve new medicines and new medical devices that are of use of everybody. And of course, they want their investments and their research and development to be fully covered by these rights. And so, of course, react against any mandatory licensing, etc. Now, going back to competition law and policy, it is true that a competitive market is a market where the dynamics of the market will encourage market players to invest, to innovate, and to obtain a large market share. So that's why competition encourages innovation. Now, for no competition law and policy across the world, and nowadays we have 140 countries that have adopted competition law and policy, so no competition legal framework considers that, oh, nothing can be done, so no interference can be even considered just because this may have some sort of impact on innovation. This would be absurd, because the objective of competition law and policy is actually to create that level playing field. So to allow also for opportunities for small and medium-sized companies, and especially to intervene when abusive behaviors, namely of market power, are identified. So from this point of view and in general, I think that this idea that regulation is a bottleneck, frankly, is something that is a little bit outdated. Most companies, again, speaking from a worldwide perspective, for an European, an American company, a Brazilian company to invest, for instance, in any African market, you need to have stability, predictability. You need to know in advance what you will be facing. So you need a framework. This is usually provided by some sort of regulation. So the good thing about international efforts, as Ronald mentioned, and I think, okay, also as an European, of course, I'm very attached to the European values and to the European achievements, which I believe are considerable. And frankly, working for the UN, I can see all over the world how much European achievements in the field of regulation, in the field of data protection, in the field of competition law and policy, of consumer protection law and policy, and other areas are looked at because they provide for balanced frameworks where interests of companies, but interests of consumers, of users, of individuals are fully taken into consideration. So this is why I think it is important also to exchange this experience at worldwide level in order, when possible, to promote convergence, but seeking to fully consider the interests of individuals and of businesses when possible. Some sort of balance always needs to be struck. That is not easy. Levels of development, of course, play a very important role in all of this. But regulation, I think, is welcomed in general all over the world, just for the fact that it creates stability, predictability, and legal certainty. Thank you.
Thank you. So now, Teresa de las Heras Ballell.
Thank you, Fabrizio. I cannot agree more with the previous remark. Indeed, from a holistic point of view, we should consider that when a society decides to crystallize its values, its interests to protect its goals as a society, indeed what is defining how everything is going to be coordinated, how everything is going to be regulated. And in that regard, the market, the economic activity, innovation, is part of this holistic approach of a society. So for me, this idea that the society and the regulation is one side of the problem, and on the other side we have the market and the economic actors trying to fight against the society is completely wrong from the beginning. So the market, the activity, the competition, everything is part of the society, and the society decide which are the values, what are going to be the interests to be protected, crystallizing, articulating a particular regulation. So I always believe that regulation should be indeed a strategical component in the business strategy. It's a strategical component as in the business plan you take into consideration other elements. Commercial aspect, competition aspect, client prices, everything is part of your business plan, as well as is the regulation one of these components. And the second idea that I think is very important, and is something that I see in United Nations or UNIDROIT, international harmonization, but also definitely in the European Union, is the idea that regulation is an enabler. Is not necessarily, and indeed it is not in most of the cases, a permanent prohibited step forward. On the contrary, many activities depend upon an extraordinarily well-settled enabling framework. So is a bottleneck? It is not. Could be a bottleneck, yes, if the regulation is wrong, if it's misguided, if it's over-regulated, but this is indeed a defect of the regulation. It's not the regulation itself of a mechanism to enabling the development of activity and social interaction. Thank you, Fabrizio.
Thank you, Teresa. So, audience, be ready. I have so many questions that I would like to ask our speakers, but it is my job. My primary job is to give you guys the opportunity to ask them questions. So, take this opportunity right now, or if you need a moment to collect ideas, I have another very interesting question with regard to the general perspective, and start collecting your ideas and write me in the chat when you want to book the opportunity to ask a question. You don't need to formulate the question to me, just tell me that you want to ask the question, but you can already formulate the question to me if that helps you clarifying your ideas. So my last question is a bit institutional already, and it has to do with engaging stakeholders. So how to make sure that all the energies that are out there in society can be brought into this debate about regulation and innovation. You know, business representatives, civil society organizations, academics. What are the enablers that we can that we can create to put all these energies to work? And
well, may I?
Sure.
Again. Well, this is also, I guess, a very topical question, and I would just comment that in the face of these the newest technologies that we are also focusing very much on, the digital technologies powered by platforms, etc., how to regulate the flow of data, protecting the rights and freedoms of people with respect to personal data. But that's not the only issue. We have also heard references to the protection of intellectual property, for example, writers of editors, etc., information which is spread through the platforms without respect by intellectual property rights. Also the issues of autonomy of consumers, etc., etc., are very, very broad and difficult issues. It's quite hard, I think, to see how the regulatory process, how in particular new developments in European Union legislation in this respect is responding to the consensual principle of participation of stakeholders. We can see in these, not only in the GDPR, but in the new copyright directive, in the Digital Markets and Services Act that the European Commission is promoting, an emphasis on transparency, on a number of principles, including transparency, participation, but how to address participation in concrete institutional terms. I think that's an issue, a question that people like us might be addressing. I would just add that if we compare the developments in regulatory and governance, that's also maybe an important term to introduce in this discussion, governance institutions and procedures that have been built up in the environmental regulatory systems, where public participation, civil society, NGOs participation has been introduced as part of the regulatory process. For example, in the environmental impact assessment procedures, if you look at this model, so to speak, I think we can hardly see how people, and including policymakers, regulators, are addressing participation vis-à-vis the new digital technologies. So that's for the moment to comment.
Thank you. So Ronald?
Yeah, a couple of thoughts here. So, and one is, Maria mentioned digital technology in this respect, and I'm going to take that out of context a little bit, I think. But one is, one thing you see is that there's a ridiculous amount of money spent by industry in trying to achieve regulatory capture. I mean, if the money spent by industry on trying to influence the EU, the European Commission and national governments, if that was spent elsewhere, then probably we could solve world hunger or something. Here's my contentious statement here. And at the same time, we also see that consumers, citizens, NGOs hardly have a place at the table. So here's an idea. Maybe we could have a sort of, in view of transparency, try to open up how much industry spends on lobbying and trying to influence agendas, and mandate that part of that amount is transferred to NGOs and consumer organizations and what have you, so that they can also take place at the table. So that's one thing. The other thing is that maybe having lots of discussions online in Zoom rather than having to travel to Brussels or wherever might also lower the threshold for NGOs and citizens to join the table. Another thing that I think, and I find that actually a very interesting, I wouldn't say development, but something that happens. Everybody knows Max Schrems, right? This unassuming Austrian student, law student, who made it to the European courts twice now, and the impact of the cases that he started on policy and regulation might be significant. So this is an individual that takes up arms to the big powers and tries to influence things, and I think he's relatively successful. So maybe we should also consider using the courts more to create a sort of a bottom-up change. That's it.
Well, you shouldn't say just that's it, because this has been such a rich policy platform that we should really take it upon. So Teresa, from the UNCTAD perspective, what would you add?
Well, you know, like other international organizations, in any case, let me tell you to Ronald, on the basis of my previous experience as Consumer Director General of Portugal, the EU, so the European Commission, also supports the participation of civil society representatives on a regular basis who are gathered to issue opinions on new pieces of legislation. So not only just through the public consultations that Maria Eduarda mentioned, of course, I think transparency, public consultation, opportunities to engage are essential, but at the EU level, there's actually support for this participation, and that is made in a structured way. So now there's always ways to improve. I can only talk about the Portuguese experience, and sometimes what you as a citizen, you can question is, why is this NGO representing Portugal or in consumer policy or whatever issues? I mean, do I as a citizen feel represented? So of course, I believe that we need to explore and to further develop a different set of avenues for the increased engagement of all stakeholders. I think that the examples that you just gave from these appeals to European courts are extremely interesting, not necessarily, I would say, available to the average citizen, even in Europe. Now imagine the rest of the world. But in any case, from UNCTAD's point of view, we do believe that it is rather easy to engage with collective representations, meaning associations, root groups, so NGOs, also chambers of commerce, business associations, and try to bring them together. What we usually can see, and of course it's a huge generalization, because in some countries there is somehow a more advanced or more developed culture of a strong civil society engagement in a number of issues. In others, there's nothing. But I do believe that we need to explore and combine all these avenues so that everybody can play a role. Now, regarding concretely the topic of innovation, I do believe that engagement with businesses and businesses representatives, and of course experts outside the strict governmental bodies, academics, why not researchers, is of great value, so that a more comprehensive, a more detailed diagnosis of what the problems are, of what the challenges are, is achieved. And this is the first step for any regulatory experience from my point of view. And sometimes, again, relating to competition and consumer protection, some of the problems or the challenges faced even within the European Union member states is that it is difficult to find the necessary expertise to understand where the bottlenecks are, where the challenges, where the options are when you're actually leading the design of new legislation. And so that's why I'm suggesting that we always need input from expert areas wherever they are. Thank you.
Thank you.
Thank you. I think that we can approach this engagement of stakeholders from two different perspectives. The first one is purely formal perspective. So we can design the lawmaking process, incorporating different stages where stakeholders can participate. So we can talk about public consultation. We can talk about, for example, the possibility of expert group intervening in the lawmaking process. We can think about observers from NGOs or from the industry, from a, let's say, purely formalistic point of view. That is always there and of course can be enhanced and improved. But I would like to add a second perspective that of course is included in all the previous remark, a more substantive engagement of a stakeholder. What that means that indeed the regulation is taking into account all the different perspectives and is considering a pure, as Teresa mentioned, a real diagnosis of the problem, the multiplicity of interest that could be affected, the academia, probably the more societal concern about the problem. How can we do that? I think that promoting different fora, European Law Institute, expert group, academia groups that are creating this very important background that should be there when the regulator start and initiate the lawmaking process. So if we consider that the lawmaking process is beginning out of the blue, from scratch, with absolutely no reference what people think about, is where this lawmaking process is going to be the link from the society. But if we already create the perfect background and we know already from the different perspectives with no specific urgency in giving a input in that lawmaking process, so the analysis is there, the discussion is there. So what the regulator should do is always observe this background, take into consideration all the different perspectives, and only then start and initiate the lawmaking process. So I think that that second element is probably sometimes not taken into consideration, but is fundamental for the purpose of our real engagement of citizenship. Thank you, Fabrizio.
So thank you, Teresa. Yeah, so we could get into the details of any of this point, but we have a question from Johanna Hilsbrich. I hope. Okay, so today real challenge there. So she apologizes because she has music in the background, and so the question that Johanna would like to ask is about the regulation of infrastructures and how to deal with network effects. So should the regulation consider all network effects? How should only some of them? How should these network effects should be regulated? And perhaps we can have an open approach to these answers. So who wants to react first? Can feel free to do it. Teresa Moreira.
Thank you. Just to launch the reply or the comments. No, for instance, when competition authorities assess, well, several cases and in different markets, they consider network effects. Now, a competition authority, let's say within the EU, because it's there is a common background that we can all relate to, but even in other parts of the world. So competition authorities have tended to become really independent within even some major developing countries. I will give Brazil as an example, or South Africa, or Russia. And so they assess cases from a strictly competition law point of view. And of course, they will consider network effects when deciding, for instance, either to adopt a decision stating that there was an infringement and imposing some sort of commitments or remedies regarding the case at stake, or also or also when they are doing merger control assessments, where usually, of course, mergers and acquisitions will have an impact in the market, and because of the need to have this broad assessment that includes, when that is the case, network effects, the remedies or the commitments or the final decision adopted will take this into consideration. Now, this is very strictly limited to the mandate of enforcing effectively competition law and policy. In most developed countries, especially in the EU, of course, I would say that we share goals. But for instance, a developing country like South Africa, they, because it's a developing country, they actually have public interest provisions in their laws. So you see, when they are enforcing the law, they could, in some cases, exceptionally, of course, with the less restrictive effect, etc., invoke other sorts, I would say, non-efficiency related goals. So I'm sorry, I don't know if this is what you had in mind, but I just tried to offer comments before other speakers follow. Thank you.
So who would like to follow up?
Fabrizio, if I may, maybe I can add some just additional remark, because Teresa has been extremely clear in defining the role of network effect. If you ask about the network effect, is something, if I understood properly, Joanna, so is something that was clearly very much associated to the first wave of digital technologies, questioning or challenging the traditional, the conventional application of competition law. Today, network effect is absolutely consubstantial of how these technologies based on multilaterality are working. And probably, and I just would like to add that provoking comment, is that network effect are not necessarily the source of negative externalities, but on the contrary, network effect could be a natural and powerful amplifier of benefits. So a network effect indeed are enhancing and multiplying the benefit and the efficiencies that some of these technologies are indeed causing or bringing about. So network effects are not necessarily, as traditionally in competition law, are not necessarily an element that could probably raise a signal and say, we have a problem here. But on the contrary, could be as well, not always, but could be as well, a very powerful tool of this digital economy, amplifying, multiplying, and definitely expanding and spreading some of the benefits of this technology. That would be just for adding that element to the debate. Thank you.
So if somebody else would like to reply, otherwise this actually was a great question to move to our next set of questions, because in Europe so Teresa was mentioning the role of competition law. Teresa Moreira was mentioning the role of competition law in these in dealing with network effects. But in Europe, we have had a glorious, I at least that's the way I like to think about it, regulatory approach when it comes to dealing with network effects in telecoms and in energy and so on. So these issue is perfect to move to the next set of questions, which focuses more on governance related issues, right? So why at some point, so in this particular case, this was an excellent case in point, because at some point we felt that competition law was not enough to deal with these this issue, and we needed to move on. And the first question that we have about governance is, okay, can regulation address permanently changing innovation without hampering technological progress? And again, so we have touched upon this to some extent before, but if you have additional ideas that you would like to share on this point, please do so. So one motion of order, we have 20 minutes left. So perhaps we could try to make the most out of this time by being concise, so that we can cover several issues. So if you feel that you would like, because we all know, right, the panel, we know the questions. So if we feel that we would like to move on something else, feel free to say so.
Fabrizio, if I may,
Yes.
I would like, in relation to this question that has been indeed already discussed in previous remark and previous comment, I would like to share with all the audience something that we are experiencing in the United Nations, the UNCTAD project and the UNIDROIT project. So far, as everybody knows very well, the principle of the technological neutrality and functional equivalence has been inspiring all the 2-decade development, legislation development on digital economy in general. So the idea of being technological neutral has been indeed at the core of this legal approach to the digital economy. That means that we are not selecting a specific or opting for specific technologies. We are open to embrace any new technological progress that is arriving. That is very interesting, but we are realizing that now probably the technological neutrality is not enough. And why is not enough? Because something that is fascinating is to see how technology is not simply replicating what we are doing in a different format or in a different medium. So that worked very well for electronic signature, for electronic document, for e-contracting. But what is happening now? When we talk about, let's say, digital asset, when we talk about cryptocurrencies, or we talk about indeed the idea of artificial intelligence driven smart contract, for instance, what we see is that we are doing different things, in the sense that if we try to replicate in the digital environment exactly the same, not only tools, but also the same way of doing things, I will give you an example that probably helped to understand, we are indeed limiting innovation in that regard. Let me use something that is very dogmatic, but helps a lot. If we talk about, for example, checks, or bill of lading, or other kind of document that we use traditionally in the international trade, if we think about a paper-based document and we think, okay, we can do electronic checks and we can do electronic bill of lading and we can have electronic warehouse receipt, because that, instead of being a paper, can be a digital asset or simply a digital document. That is not enough. Because if we think about how we use checks, we need the paper and everything that holding a paper entails. But if we have simply information that is representing my right or is representing my entitlement, what we can do with that is extremely varied. We have many possibilities to do things without a paper. So we, in my opinion, and that is completely a personal contribution, personal approach, we have to go beyond technological neutrality. We have to be neutral also in relation to the different models, the different architecture, the different procedures. So we can use different process, different architecture, different models to do the same thing when we incorporate digital technology. That is for me something very important to bear in mind, and that I appreciate now that is indeed permeating the new project that we are working on at United Nations and UNIDROIT. just a comment for your consideration and discussion. Thank you, Fabrizio.
Thank you. Ronald?
Yeah, I agree with Teresa Rodriguez on many points, and indeed it's so an important. I think we need to move towards a set of principles, and we already have many of them, and technical neutrality is one of them. Although that's not, there. You can't push that to the limits, but that's the idea of principles anyway. So it is an important sort of foundation, but others are precautionary principle. And there's a number of substantive principles, I think, in the European legal order, such as dignity, autonomy, what have you, and those should be put more to the fore as sort of backdrops against which indeed people have freedom or room to innovate. But there's an interesting debate, which was Chris Reed wrote a book that infuriated me a number of years ago, because he said technology regulation is bound to fail because it's way too precise. I don't agree with him, but there is this tension between being very concrete and on the other hand being very abstract, because abstract also isn't a cure to everything, because then you have interpretation issues and what have you. But I think a principled approach and maybe sunset clauses and regulatory sandboxes are a way to experiment a little bit more in a structured way, because every regulation, of course, is temporary. I mean, it can be changed always, but making that more part of the arena, that we tried this out for a couple of years, which provides a certain legal certainty and predictability, and then we evaluate and see whether we move on or not. But and the other thing I want to say that is regulation is that it's generally seen as lagging behind innovation is not a design flaw, it's a feature because of legal certainty and because we've thought about things that we cherish as public values. Yeah, that's my contribution here.
Thank you, Ronald. Okay, so if our speakers would like to intervene on this point, otherwise I'm moving to the next question. Okay, so I'm taking notes and this document is becoming longer and longer. So the next question is pretty much connected actually with what Ronald was saying, because we would like to prompt a reflection on how the law can be a step ahead. So Ronald just told us that in a way lagging behind is a feature, but to some extent we would also like the system to be as quick as possible in addressing new issues. So how can we do that?
May I?
Yeah. Then we have Ronald in the queue.
Yes. Well, very briefly, one idea that came to my mind in this respect, thinking again about the European Union framework, is the role of think tanks that the European Commission, in fact, very often organizes to bring new ideas, and not only that, but to, let's say, to gather stakeholders and representatives of all kinds of relevant interests and values, etc., to think about the future. Well, that's all for the moment.
Thank you, Maria. Ronald?
Yeah, so one thing that we have on the table here is the Collingridge dilemma, right? So we don't know how technology will evolve, and if we intervene too early, then we might hamper it. If we intervene too late, then we're already in a path that we can hardly change. So so I don't think there's a clear answer to when and how to intervene, but we have to be aware of that. And a completely second. What was said about foresight. We have to try to look into the future and what the next steps will be in innovation and development early on. And I think there could be, I mean, in the late 90s, technology assessment was quite common in many countries, and somehow that subdued a little bit. But I think we need to have think tanks and what have, I don't know how to set it up, but try to look ahead. And the third thing I want to say is we're stuck in thinking from the perspectives that we already have and the sort of the regulation that we have in place, and see that as the sort of the hammers in our toolbox. But we need to, I think we need to move away a little bit and focus more on what kinds of risks do we actually want to prevent in this world. And look from risks and harms and try to then reconfigure what does that mean then for things like automated decision making, for facial recognition, for AI in general, rather than pushing forward the things that we already know. So and that goes back to this principled approach. So the principles should be based on the values that we want to protect, and I don't think we have a clear view on what those are and how that then materializes.
So, Fabrizio, very briefly, if I may, unless you would like to, yes.
No, please. I'm just the moderator here.
Thank you. I think that is also very interesting to see how a combination of soft law and hard law is also producing a very interesting, active, and at the same time flexible lawmaking process in the following sense. If we take a look at, for example, the United Nations, but also the European Union approach, we see, for example, how the United Nations start with the legislative guide and then prepare some principles related to the topic, and then decide whether to crystallize that into a model law or in a convention. So why is that good? Because if this list of principles of this legislative guide is misguided or is not understanding properly the reality, it's very easy to change. And definitely is more complicated to change a convention that has been adopted. At the same time, the European Union, for example, decide to adopt first some recommendation, let's say, on how to tackle illegal content in electronic platforms, just recommendation, then communication, and then the decision whether a directive of the regulation should be adopted. So probably this idea of step-by-step from soft law to hard law is another element that we could consider as promoting agility and flexibility of the law. Thank you, Fabrizio.
Thank you, Teresa. Teresa Moreira.
Thank you. Just very briefly. No, I absolutely agree with this combination of approaches. I think that, of course, even for the United Nations, there are, of course, values and principles. I would agree with Ronald that it's not always easy to agree on the translation of these principles and values, especially, I mean, considering a worldwide approach. And so we need to be very cautious. And what Teresa was saying, I think it's very important. I think one needs even sometimes to experiment, depending on the topics of the, let's say, the counterparts or the direct constituents at stake. I think that needs to be considered and explored, well, depending on the matters at stake. I would make the case already for the strong reference that regional organizations can play, let's say, again, from my point of view, taking into consideration a worldwide approach. Because going back to something that was discussed, I did a lot of capacity building in Brazil three years ago or something, and it was at that time not only government officials and business associations as the judiciary were already extremely interested in the GDPR. And at that time, the legislation of data protection in Brazil was still in discussion. And you see a big market, a big country, but a big emerging developing country such as Brazil, extremely interested in the rules of the EU that are, of course, I would say more complex, more ambitious, because as everybody has said, are related to the principles and values of the EU, and yet serving as a reference, not just for the businesses that actually need to comply with these rules when selling to the internal market, but you see other stakeholders, such as the judiciary, being extremely interested in this. So I do believe that the EU has several very successful achievements that are of interest across the world. The OECD is extremely strong in everything that relates to research. As Maria Eduarda mentioned, I'm a big fan of the OECD work. Of course, from the UN perspective, one needs to be a little bit cautious, as these very good examples need to be perceived just as references and not really like recipes between brackets that one is suggesting less experienced, smaller, least developed countries to adopt. But I wanted to take this point because I know it's one of the questions that will come, that I do believe in worldwide, in international standards and international cooperation, of course. But in every area that I've worked so far, I have seen the strength of regional cooperation, usually attached to regional organizations, even in developing countries. I would just underline that there are a number of regional economic organizations in the African continent, but also regional from the point of view of informal cooperation, so networks. And I say this because I'm sure Teresa is also aware of this within the UNCTAD, and other colleagues will also be. And because we don't have much time, this will be my last intervention. Thank you very much.
Thank you, Teresa. So we have a few minutes left, and what I would like to do is take inspiration by an Italian journalist who makes his interviews in the following way. He gives to the interviewee the task of asking himself a question and giving himself an answer. So in your last intervention, before thanking you so much for being with us, I would like to ask you to ask yourself a question and give yourself an answer. Starting perhaps with...
Yeah, sorry. It's my turn, I suppose. Well, this is a challenging suggestion, asking myself a question. In fact, from listening to these very, very rich and inspiring presentations and questions and answers this morning, the problem is to choose a question, because I have a list of questions in my mind that I will be considering in the near and not so near future, particularly on topics that I do not know enough, such as the role regulation can play in practice in furthering technological innovation, for example, competition, etc. But the question that I would have an answer to, that's it. I have questions, but maybe to think of the answers would not be so easy. But I don't want to take your time. There is just to take one among many possible questions that was raised by this last intervention by Teresa, with respect to how, not disregarding the role and importance of regional action, real cooperation, etc., to provide guidelines for better regulation of all these technological changes we are facing. How can mechanisms be thought to articulate the different levels of governance and regulation, or regulation and governance? I mean, the international one, the regional one, the national one. We have been considering the three, in fact, here. People looking from Europe, from the United Nations, how these mechanisms might be furthered. I don't have, the problem is that I don't have an answer to that, but I don't want to also to take more of your time.
Thank you. Next will be Ronald.
This is an incredible challenge, of course, but you know that. I would say, if I would ask myself, what is the lesson you take from this wonderful webinar, is you know nothing, Jon Snow. What the realization is that what I already knew was a multidimensional space is even a way bigger multidimensional space if you take on board the United Nations, which is largely beyond my scope. I mean, my focus is pretty much on the European Union and the European Commission. So, but of course there's a lot out there as well, which makes it even more multi-level, multi-anything. So I have high respect for people who try to draft actual regulation because they at least try to manage to get something in writing, whereas I'm like, where to start? Yeah, so a non-question with a non-answer, but that's where I am.
To be honest, that also happened very often in the Italian program I was referring to. So Teresa Moreira.
Okay, I will ask myself the question that I want to answer. That's just this. So how can I, in my current job and within UNCTAD, do something to advance this debate? I thought it was extremely interesting. I have to say I very much miss sort of policy discussions, because of course with the mandate of UNCTAD, as you have understood, we are a little bit demand driven by member states, which is normal. And so not always we have these opportunities. What can I do and what can UNCTAD do to advance this debate? For this, I do have an answer. I will organize next year either webinars or if by any chance by the end of the year there will be no more travel restrictions, at least within Europe, I would be very happy to organize even a discussion in Geneva, in the Palais des Nations, probably focusing a little bit on a sector-specific or on a team-specific issue. But I learned quite a lot from my fellow panelists, and I think it's very good. And this is one of my jobs, I believe, it's to showcase good examples, to disseminate knowledge and information, and being at personal level a strong believer in the European Union, I do make the case for sharing the best possible examples, because this is really very much appreciated by the representatives of all UNCTAD member states. So this I can do, excuse me, and so I hope this will be the start of a new series of discussions. Thanking very much Jorge Morais Carvalho, the Universidad Nova, the Legal Hackers, Fabrizio, and everybody for attending. Thanks.
Thank you, Teresa.
Thank you, Fabrizio. So I have decided to raise that question that I want to answer with the thing that I believe should be and what I'm working for. So the question would be, should we regulate on a national level or a regional level or on a global level? And definitely the answer for me is the result, in my opinion, should be global. So we have to work for international, strong international and legitimate international organization producing global rules, but the process has to be decentralized, cooperative, multi-jurisdictional. So I'm working for that. I am promoting this vision of respecting international organization and contributing from the different legal tradition, the different legal cultures, in order to produce global rules that are sensitive to different values, different regions, and different legal cultures. Has been an excellent webinar. I very much appreciate Jorge, Fabrizio, João, Nova School, and the Legal Hackers Lisbon for the invitation, and has been a great honor and a privilege to be with you, Maria, Teresa, and Ronald, in this discussion. Thank you very much.
So I'm giving back the floor, I think, to the organizers, and my role concludes here. Thank you so much, really.
Thank you so much to all of you for such an interesting morning today, and I hope to meet you again soon in person. and to be able to have new sessions like this one in the near future. Thank you so much and have a wonderful weekend. Thank you very much.
Bye.
Bye-bye.
Thank you all.
Thank you.
Bye.
Take care. Bye-bye.
Take care.
Thank you, guys. Thank you very much.
Thank you. It was a great pleasure to
Thank
have
you.
you here.
Thanks for organizing this.